All right, so this next part, we're going to be really focusing on due process. So we've talked about incorporation, now we're talking about due process. We're going to focus on the rights of the accused. So if you get accused of a crime, yes, you have rights, but it's worth knowing how they work. So a lot of this is going to be based around the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Mouthful, worth saying. Be aware of this. This question of what is and isn't a reasonable search or seizure is going to come up a lot as we move forward. All right, so a search is legal if. First of all, it's legal if the person consents to the search. They can ask you and you can say sure, and they can search. That's straightforward and simple. It's legal if they have a search warrant, which is an order from a judge authorizing the search. And then for the most vague, going backwards up the chart here, is probable cause. If the officer has good reason to believe a crime has been committed, they can search or look or enter. And what determines probable cause is subject of great debate. We'll get back to that here in a bit. There's going to be some court cases on this. So a little bit on probable cause. If an officer makes an arrest, they can search the person under arrest and anything in plain view, and things and places under your immediate control. So like the room you're in. It's very limited. Kinda. We'll go with kinda. So there's this thing called the exclusionary rule, and this means if any evidence is obtained illegally, it can't be used in a court of law, all right? But the person may still be tried using other evidence. So this exclusionary rule is very controversial. Why? The first one, on one side, is it may allow guilty people to go free. So if the police jump the gun and search without a warrant, they find the drugs, assuming they didn't plant them, we're just assuming that they were your drugs and the police found them, can't be used against you, all right? So it makes the job for law enforcement tougher, excuse me. Second thing about why people are kind of opposed to this is it really is out to protect the rights of the accused, and it makes, like I said, it makes the job for law enforcement less easy. Avoiding that word. All right, Mapp versus Ohio, Supreme Court case number 1. I don't think this one's been on one of your sheets yet. Don't worry, it'll get there. All right, so Mapp versus Ohio. I'll let you read the first part about the facts. The big question is the materials confiscated from an illegal search, could they be used against them, and were they protected by the First Amendment? All right, so there are a whole lot of questions about having obscene materials and what is and isn't legal for your own viewing. The court held that any search or seizure that violated the Fourth Amendment, anything that comes as a result of that can't be used in court. It did not address the First Amendment issue of the ownership of obscene materials. They just kind of sidestepped that. And the courts they make a habit out of that. So, that exclusionary rule I mentioned before, there are exceptions. So, objective good faith, if a police officer gets a warrant that they believe is valid, but maybe they searched something they shouldn't, but they believe that they were doing right, then based on good faith, they're all right. And that's complicated and vague, and yes, it's open for debate on when this does and doesn't apply. The other limitation to it is the inevitable discovery rule. So essentially, if the police find something and they didn't quite go through the process right, but what they found would have been eventually found, it can still be used at trial, even if they obtained it illegally. And that's just complicated, but it is an exception. All right, so some contemporary Fourth Amendment issues. So with the passage of the Patriot Act, which you all should be super familiar with, all right, which allows for the warrantless searches of cell phone data. Supreme Court said that's unconstitutional. The Supreme Court case, Carpenter versus U.S., is not one you're required to know, but it's one worth taking a look at. Excuse me. Sorry, hang on. So, it put limitations on the bulk collection of telecommunications data, and it brings up the big question, should civil liberties be limited in exchange for promises of better security? All right, so Fifth Amendment. We've looked at it a few times now. No person shall be held to answer for capital or otherwise infamous crime unless on presentment or indictment of a grand jury, nor, skipping down here, shall any person be subject to the same offense, for the same offense, be twice put in jeopardy of life or limb. All right. Also goes on that you can't witness against yourself. All right. Nor can you be deprived of life, liberty, or property without the due process of law. Here we're back to this again. All right, now how are we applying this? I guess it's also important to look at the Sixth Amendment. Let's do that first real quick. So we looked at the Sixth Amendment a little bit last week. If you looked at the Gideon v. Wainwright, which establishes the right of counsel for the defense. The Sixth Amendment also guarantees you a speedy and public trial and an impartial jury. All right. So, got those things. Now we're going to talk about the Miranda rights. You have likely heard of them. If nothing else, you've probably heard them used in a cop show at some point in time. So, essentially, in the case Miranda versus Arizona, it was ruled that suspects in custody must be informed of their Fifth and Sixth Amendment rights. Essentially, the court said, you don't really have rights if you're never told that you have rights. So if you don't know about them, you can't really have them. It's very circular, but it kind of rings true. So it is possible for someone to say something incriminating before their rights are read, and that's a complicated case, but it can happen. All right, so last week we looked at Gideon versus Wainwright as one of your cases. You should have watched a video about it. And it's what establishes that right to a defense. You can click on this picture here. It'll take you to a different video about it where you can learn more about it in greater depth if you're fascinated. It is an interesting case to look at for sure. All right, it's Riley versus California, 2014. All right, so let's talk about Riley. Essentially, this dude Riley was pulled over, all right, for driving with expired tags. Not the worst thing that could happen to you, but, that's just a lapse of judgment. Well, his license was suspended, so the law said police were required to impound the car. Not a big deal. Well, when that happens, police search the car. This is to kind of protect the police. So when it's impounded, once it's eventually returned, anything in it can be returned to you. Well, when they did that, they found some contraband, shall we say. Particularly, they found firearms that he shouldn't have had. Now, also, when you are arrested, remember, police can search you. And when they searched Riley, they got his phone. All right, so they got his phone. They looked through it and they find gang material inside his phone, some picture evidence. Things aren't looking good for Riley. They're going to determine that he is affiliated. So the big question here was the evidence admitted at his trial from his cell phone discovered through a search that violated the Fourth Amendment right to being safe in his own possessions. Well, that's the question. So ultimately, the court would rule yes. The materials that were got in this manner were reasonable. The search was reasonable. Sorry, let me be more clear about that. While it's definitely a complicated case versus with the fact that yes, they can determine he has a cell phone, but necessarily going through the cell phone is questionable. They did determine that in an emergency case, these things could be done if there is a compelling interest, which there was in this case, given that they'd already found the guns. Ooh. All right, so our next case is, oh, I went too far. Carpenter versus the United States. This is a 2018 case. Essentially, oh, go back, darn it. There we go. Essentially, the FBI was after this series of armed robberies, and they were tracking these guys, and they got one of them. All right, and this guy gives his phone number and his buddy's phone numbers to the FBI, and the FBI applies for an order to get transactional records for these phones. They then use that information to prove that the people were there at the sites of the crime when they're used. They use essentially a whole lot of GPS mumbo jumbo. The big question here is, was the seizure, was the use of the phone records in this case constitutional, or did it violate the Fourth Amendment because they didn't have the right kind of warrant? Boiling down to a question of did the police have probable cause in order to do this? And the Supreme Court is going to say yes. The Fourth Amendment protects not only property interests but also reasonable expectations of privacy. Oh, I think I just lost my window there. I don't know how to bring that back. Sorry, I'm afraid I lost my spot here. Essentially, yes, the court can have access to your cell site location. However, they open up a whole lot of other questions here regarding like the issues of privacy and cell phones and the way that the technology has developed. And I will let you read this to better understand that. I'll give you a second here. All right, you should have been able to pause that and checked it out if you wanted to. All right, so you want to make sure you can answer these questions. What 3 factors can make a search by police legal? It was in the first set of first few slides there. The Miranda rule, you have a right to remain silent. Anything you say can and will be used against you, whatnot. The exceptions to that, all right. Gideon versus Wainwright, and which amendment was incorporated to the 6th. All right, why might people who are more concerned with law and order oppose the exclusionary rule? Okay, and identify 2 limits the Supreme Court has placed on the exclusionary rule. All right, we've definitely talked about all of these things, so make sure you can answer them. Okay, these are all things you will need to know. Thanks for tuning in. I hope you learned something. Look forward to seeing all of you in virtual land here soon. All right, see you guys. I'm out.